We're going to look at some of the top mistakes that landlords make, and it just happens to be that many of these are violations of the Federal Fair Housing Act. Number 1. Failing to document what rent specials were offered to each prospective tenant. Do you know that a prospective tenant can make an accusation that you discriminated against them? And if they do, the Department of Housing and Urban Development will ask you for all kinds of documentation to see if you do things in a uniform fashion. So make sure everything you do is well documented. Number 2, asking questions that can be deemed discriminating. A landlord should refrain from asking certain questions to a prospective resident. This is one of the most serious legal mistakes that a landlord can make. Examples would include how severe someone's disability is, or what is their marital status, or are you pregnant now? A landlord does, however, have the right to use standard tenant screening methods like credit and reference checks. But weeding out tenants based on the use of discriminatory information is definitely illegal. Number 3. Failing to research whether or not there are additional protected classes that go beyond the federal 7 that might be in your state, city, or your local municipality. Don't just go online and Google what are the protected classes in my neighborhood, because the internet's not always correct. You need to go to your local Fair Housing Council and ask them and get it in writing. Number 4. Failure to make disclosures to prospective tenants. So what do we mean by disclosures? Well, if there's mold at the property and you don't disclose that, that's something that can come back and be a problem later on. If there's any sex offenders that live in the area that you have actual knowledge about, a tenant could actually sue you for not bringing it to their attention that there's a sex offender in the neighborhood or what they should do in order to check. Also, if the property was built before 1978, federal law requires that the landlord disclose whether the property contains lead-based paint, and there's a federal disclosure form that's used. Did you know that in some states it's required that if someone died at the property, that you have to disclose that? You need to check and find out if that applies in your area. Number 5. A common complaint that many fair housing enforcement agencies receive is that members of one protected class get their maintenance requests handled more quickly than members of another protected class. In other words, again, discrimination. So to avoid this type of allegation, make sure to have thorough documentation of all work requests as well as maintenance actions that have been taken for at least a year or more. And this should all be based on a clear, established response policy that you have in your policy and procedures manual. Number 6, failure to train everyone who interacts with customers and tenants on fair housing laws. So we're talking about your office staff, secretaries, the maintenance people who work on your property, the people who cut your grass, anyone at all who deals with your people or your residents. You need to make sure they understand fair housing laws, because it'll come back and bite you if there's a problem. Number 7, when you allow your maintenance team to choose which service requests to respond to in the order of their choosing, as compared to following the date received or the date made, that can become another discrimination problem for you. So make sure that you follow your office policy and that they're actually doing it in the order received. Number 8, using illegal provisions in your leases. A residential lease should not contain provisions that violate any state or federal laws. It turns out that an illegal provision may actually result in the landlord being liable for monetary damages to the tenant. Number 9 might really surprise you. Evicting a hoarder instead of accommodating them for their disability. Yes, we've all seen the show on TV about hoarders, but now it's considered a disability. If you run into this situation, be sure to check with your local housing council to find out how to handle the situation. Because what most people don't realize is that hoarding is considered a disorder and protected under the Federal Fair Housing Act. Number 10. Refusing to allow a tenant to have a service animal because your landlord or your community does not accept pets. Most people don't realize that a service animal is not considered a pet. These animals are actually there to help disabled people overcome the limitations of their disabilities and the barriers that are in their environment. So because they are not pets, keep in mind that you cannot charge additional deposits, you can't have size, weight, or breed restrictions, and anything along those lines can get you into a heap of trouble. Thank you so much for watching. If you found the information helpful, we'd really appreciate if you could like this video and click subscribe.